Sure, if you would. It's the same as this.
Okay.
It's got that,
Oh.
this is also.
Gotcha.
So yeah, just come up with this.
Okay. I got you. Thank you. Thank you. No,
Use it or not, and she will.
no, I'll need to.
And attorneys, can I see you up here for one moment briefly, please? And we're not on the run. All right, everyone. I'm just going to give that attorney just 5 minutes because believe it or not, sometimes attorneys have more than one client on the docket. So he just needs to have his client sign a document and then he'll do that. All right. All right, ladies and gentlemen, good afternoon. All right, so it is not 107 degrees today, so nobody should be feeling drained. Good afternoon, everyone. That is awesome. And I will tell you, the court reporter is going to appreciate it when everybody speaks loudly. So I am Judge Stephanie Boyd. This is the 187th District Court, and you are on the 4th floor. So what floor are we on? What's the court number? Who's the judge? Somebody even added the first name. All right. And I know what you're probably saying. We know where we are. Why is she asking us this question? The reason why I asked that question, I've learned since I've been on the bench to ask that question, is because whenever we take a break, you all have to step outside. And sometimes I give you a break because someone needs to go to the restroom or something else. And when all of you leave, we can't start until everybody's here. And it never fails that somebody goes missing. And then we have to wait and we're trying to find them. And I've had people say, I looked up, everybody was gone. I didn't know where I was supposed to be. And we actually had someone who was down the hallway trying to get selected on another panel. And so we had to go grab them. So believe it or not, that does happen. And so the reason why I tell you that, because if you don't want to ask anybody, if you get lost, you can say, I know it was on the 4th floor. or either if you want to ask somebody, there's only one 187 district court in all of Texas. And in this courthouse, even with the courthouse next door, there's only one Judge Boyd. So if you know any of those, they'll be able to point you in the right direction. So this case is the state of Texas versus Melvin Owens. I'm going to have the parties introduce themselves to you for the state.
Good afternoon, I'm Ruben Herrera.
It's Robbie here.
And for the defense,
William Davidson and Robert Featherston here setting up the technical things will also be helping me for the jury selection.
all right. And then Mr. Owens, if you'll introduce yourself.
My name is Melvin Owens.
All right, thank you. Now, to my left, I have the court reporter. Diana, could you raise your hand? I always do my best where I can to make people's jobs as easy as possible for them. Because I always said when I was working for somebody, could they please make my job easy, right? So we can make her job extremely easy for her today. She is taking down everything that everybody says. And if you can imagine, that's difficult because some people whisper, some people talk slow, which she likes, and some people talk very fast. So to make her job easy, I'm going to need everyone to make sure that you keep your voice at the level that I have my voice. Is everyone able to do that?
Yes.
All right. So this is what I want everyone to do. You have something in your possession that is very valuable. They're cards with numbers on them. Could everyone please raise your card for me? Now, when I tell you to lower your card, lower your card. Everyone in this box, lower your card. Everyone on this front row that I'm pointing at right now, please lower your card. The people who still have your cards up, whenever someone asks you a question and you're answering it, if you can, I'm going to need you to stand because believe it or not, the acoustics in this courtroom are horrible. So if you are not standing, the court reporter is going to have a hard time hearing. So can everyone do that for me?
Yes.
I have faith in this jury that you will be able to do that, but I will tell you so far, not a single jury that we have had has done it. So if you see someone who's sitting down and speaking, just tap them a little bit and say, we want to be successful on standing up. All right, so you can lower your card. The other thing that will make her job easy, she can take down two people talking at once, but that makes her job difficult. So if everyone can agree that only one person will speak at a time, and if something applies to you or you want to say something, if you will raise your card, your number will be called and then you can speak. Does everyone understand?
Yes.
All right. Now, the charge in this case is aggravated assault with a deadly weapon and also assault, choking, strangulation. Now, I realize that sometimes people say, why couldn't I get a civil case where somebody had a car accident, it's the insurance company or something else other than a criminal case? But what I can tell you, in order to have a jury trial, guess what we need? Jurors. So in this courthouse are the criminal cases. The courthouse next door, they call it the historic courthouse with the green rooftop. They handle all civil matters. So I'm going to come back around to the charge as I go through my topics with you. When the defense attorney speaks to you, when the state attorney speaks to you, they are going to be talking to you about hypotheticals. Neither the state nor the defense can tell you what they think the facts of this trial are or what the facts of this case are. So when they speak to you, remember, They're not speaking about this specific case. They're speaking in hypotheticals. Does everyone understand?
Yeah.
Now I'm going to see how many bad drivers we have in this pool. How many people here have had a traffic ticket? Oh, remember to raise your card. We're testing you here. All right, so we do have a pool that's made up of bad drivers. There are a couple who've never had a traffic ticket. I can say that. I've had a traffic ticket before. So let's say you have a traffic ticket and it's for failure to abide by the yield sign, which I've discovered in San Antonio, like many states and cities. Nobody knows what the yield sign means. Some people think the yield sign is a stop sign. And when you're behind them, you're in your mind, you're like, that is a yield sign. That is not a stop sign. We are never going to get on the freeway because you're not abiding by the yield. Let's say, for example, you don't abide by the yield sign. Officer turns over on his lights, officer pulls you over and they give you a ticket. I've only had one ticket. When I had it, I want to say I was 18 maybe. And so now I'm about 24. Okay, that laughter should not have been there. You should have said, man, she's super intelligent to be up there for 24. So at that time, they had a ticket book and they would write in and then they would hand you the ticket and then they have to go to municipal court or wherever they go to turn their tickets in. Now my understanding, it's all electronically. When you accept that ticket, you're not saying you're guilty of what the officer is saying you did. That ticket is to tell you, this is what we're saying you did, and this is the date and the time and place where you need to be in order to go to trial if you want to go to trial or whatever you want to do with the ticket. In felony court, the way that happens here is through something called an indictment. An indictment is not evidence of guilt. It's not to be taken by you to mean anything. It's just a means whereby someone knows what they're being accused of and they know where they need to be. Does everyone understand?
Yes.
Is anyone going to hold it against Mr. Owens because he has been indicted? Okay. Now, there are certain constitutional rights that everyone has in the United States. I know some of you have probably seen Mannix Beretta. Where are my Beretta? Thank you. Other people pretending they've never seen Beretta, Mannix, or Barnaby Jones. I know they have. But the practice, there are a lot of legal shows on now. And I do know that sometimes the legal shows are not showing what really happens in court. But one thing they always have are certain constitutional rights in there that are true to how it exists in the real world. One of them is the right to remain silent. So what that means, in criminal cases, you do not have to testify. Now, I've been a defense attorney, I've been a prosecutor. There are many reasons why people don't want to testify. Sometimes people have a fear of speaking. People have told me that is one of the biggest fears that people have is speaking in public. I can't begin to imagine how it is to sit in this chair and everybody's staring at you because this is the witness chair. Now, sometimes people are accused, they don't testify because maybe they're attorney, and I've done it in some of my cases that I had as a defense attorney, where I've told them, state and prove their case. There's no need for you to testify. Sometimes you have clients who are extremely afraid of public speaking. Maybe they stutter, maybe they sweat a lot. And sometimes they will think, oh my gosh, people are going to see me sweating, so they're going to think I did that, but then I'm sweating because I'm so nervous. Sometimes people think someone being nervous is a sign that they did something. So there are many reasons why people would decide not to testify. But the key point here is that you have a right not to testify and a right to remain silent. Is there anyone here who's going to hold it against Mr. Owens if he decides not to testify?
No.
The next thing is everyone is presumed to be innocent. What does that really mean? That means that as we sit right now, if you were asked whether or not Mr. Owens is guilty or not guilty, what should your answer be? And that will be because you have not heard any evidence in this case. So this is what that means. That means that the state must prove its case. They have the burden. The defense doesn't have to do anything. When we were in law school, they would always say the defense could do crossword puzzles. They could play video games. They could watch television with their earphones in. Now, I will tell you, we never did that as defense attorneys, but they say that to make sure that you understand they can do all of that because they don't have to prove anything. If you're ever on a jury trial and you start asking yourself, well, I wonder why the defense didn't present this, or I wonder why then they didn't do this. That means that you have shifted the burden to this table, which you are not allowed to do. The state has to prove the case. The defense does not have to prove anything. Does everyone understand?
Yes.
Now, there's the burden of proof in criminal cases, and it's called proof beyond a reasonable doubt. So the state has to prove its case beyond a reasonable doubt. What is that definition, you may ask? When I first graduated from law school, everybody had to know that definition. If you didn't know that definition, you felt like such a failure because your professors would make you feel like you were such a failure. When I had my first jury trial, I knew that definition forwards and backwards. I still know it. I knew where to place the comma at to pause. I knew where to put the explanation point. I had my first jury trial. After my first jury trial, you know what happened? There's no longer a definition for proof beyond a reasonable doubt. So if ever I'm in a game show and they ask that question, I know I'm going to get it right, but there's no longer a definition. So as my time as a prosecutor and a defense attorney, yes? Oh, you had a question? Oh, just an itch. Okay, that's okay. So as my time as a defense attorney and a prosecutor, whenever I was doing jury selection, I would tell people what proof beyond a reasonable doubt was not to help you understand it. So for example, in the historic courthouse, I've told you that's where they try civil cases. Car accidents, things of that nature, it's usually preponderance of the evidence. More likely than not, something happened. So if ever you're on a jury trial and it's a criminal case and you're deliberating and you start saying, well, I think that happened more likely than not, you know that you are not at the correct burden. You're at the civil side burden. And proof beyond a reasonable doubt is the highest burden we have. The other burden they have on the civil side is called clear and convincing evidence. And that's the evidence they use when they say, you're not a good parent, you're a danger to your child, we can't trust you to be a parent. So they terminate your rights. So legally, you will no longer be a parent to your child. That's the other burden on the civil side. And that's the highest burden they have on the civil side. That burden is still not higher than proof beyond a reasonable doubt. Does everyone understand?
Yes.
Now, there are two phases to a jury trial in Texas. The first phase is what's called guilty, not guilty phase. Some people call that first phase innocent or guilty phase, but that's not really correct. Because the first phase of any criminal jury trial is really, did the state prove its case or did they not prove its case? It's not really you're finding someone innocent. Does everyone understand?
Yes.
The second phase of a trial, you only get there if you find someone guilty. And that second phase is called punishment phase. In Texas, anyone who is going to a criminal jury trial must make an election or selection that if they were found guilty, who would they like to determine punishment? They must make that election. It does not mean that they're saying they're guilty. It's just that the law says if you are found guilty, you have to make a decision on who you would decide to choose your punishment. In this case, Mr. Owens has decided if he were found guilty, he would ask for the jury to assess punishment. Is there anyone here who's going to hold it against Mr. Owens because he has made the determination that if he were found guilty, he would ask for the jury to assess punishment? Anyone? All right. Now, with regards to punishment, is there anyone here who cannot sit in punishment of another? And when I say that, I mean there's some sort of religious reasons or that type of reason. So I want to talk to you about ranges of punishment. And whenever I talk to people about ranges of punishment, again, these ranges of punishment are to be considered if someone were found guilty. With regards to aggravated assault with a deadly weapon, the ranges of punishment in those cases are usually anywhere from 2 to 20 years in prison and up to a $10,000 fine. For assault, choking, strangulation, the ranges of punishment for those cases are usually anywhere from 2 to 10 years in prison and up to a $10,000 fine. Now, if you are sitting on a jury and you are doing the punishment phase, you must be able to consider those entire ranges of punishment. And when you think about it, in Texas, the ranges of punishment are wide. So it could be 2, 3, 4, 5, 6, all the way up to 20, 2, 3, 4, 5, 6, all the way up to 10. Now, when I talk to you about range of punishment, it's whether or not you acknowledge that is the range of punishment. Is there anyone here who cannot internalize and acknowledge that that is the range of punishment if somebody were charged with aggravated assault with a deadly weapon or choking strangulation? Now, I can't ask you whether or not you would give somebody 2 years or 3 years or 10 years or $10,000 fine unless you knew specific facts of a case, correct? So in this case, I've already told you the defense in the state, they will only be able to talk to you in hypotheticals. So they can't tell you what they think the facts of this case are. But what I need to know from you all is, one, you'll be able to consider the full range of punishment if you were selected on this jury, and that whatever the facts may be, if you were to find someone guilty, you will be able to look at the facts you have and potentially make a decision on punishment. Is there anyone who would not be able to do that? Is there anyone who would not be able to apply whatever facts you may have in whatever case it may be? And if the range of punishment is 2 to 20, could you look at facts and say, well, maybe this is the case where I would give 2 years, or maybe this is the case where I would give 10 years. Is there anyone who cannot do that? Okay. Now, the next thing I want to talk to you about is languages. I love languages. I did not plan to be in Texas. I'm from Louisiana. My plan was to go to France. I should have been retired at the age of 21. Nobody tells their children that you cannot retire at 21. So in school, I took French. I took French in elementary. I took French in junior high. I think now they call it middle school. I took French in high school. I took French in college, and that's where I thought I would be. My classmate, Tanya, said, Stephanie, you should come with me. We should be taking Spanish. I'm like, girl, I'm not taking Spanish. I have my dreams. I'm going to be. And I said, we're in Louisiana. We're going to be speaking French. So she took Spanish and I ended up in Texas. And to this day, she tells me, girl, I told you, you should have taken Spanish. I did not. But I do love languages. When I went to undergrad, grad school, and law school, everybody could speak a lot of languages. And usually you'd be shocked, the people who are from the Middle Eastern countries, they usually speak, some of my best friends speak 4, 5, 6 languages. And I'm like, oh, I wish I could. So they would try to teach me. And I do know hurry up in almost every language because that's the only thing that I could grasp, especially with Navajo. Navajo was very difficult for me. So is there anyone here, and this is a test for you to raise your card. Is there anyone here who English is not your first language? Raise your card. All right, number one. And once I call your number, you can lower your card. 20, 40, and 47. Is there anyone else? And number 60. Number one, what's your primary language, your first language?
Spanish.
All right. And have you been able to understand everything?
Yes.
All right. And how do you say hurry up in Spanish?
Apúrate.
All right. See, people say it in different words. Yes, I like the second one. All right. It's easy just because it's easier for me to say. Number 20.
Spanish as well.
All right. And have you been able to follow everything?
Yes.
Did he tell me how to say hurry up correct?
The good word, yes, not the bad.
Okay, thank you. Believe it or not, I know the bad one. All right. Yeah. Number 40. Yes. Somebody nudge number 40.
Spanish as well?
All right. Have you been able to follow everything?
Yes, ma'am.
All right. And have they been telling me how to say hurry up appropriately?
Nicely, yes.
All right. Thank you. You know, you guys are the first group to say they've told you how to say it nicely. Number 47.
My first language is Filipino.
We've had that before. And how do you say hurry up?
Dalian mo.
Thank you. And number 47, have you been able to understand everything? Thank you. Number 60. Yes, what is your first?
Spanish.
Spanish? And have you been able to understand everything?
Clearly.
Are you happy that they didn't tell me the bad way to say it?
Not sure I know the bad way.
All right, thank you. All right, so the next question I'm going to ask you all is about time constraints or travel. Is there anyone here who has travel plans? You have non-refundable tickets. You can't give them to me. Is there anything of that nature? Somebody laughed, but no, you can't transfer it to me. Okay. All right. Just raise your card if there's some sort of travel issues. And if you want to tell us about things that you're doing this summer, I can tell you we're not going to be here till November, but sometimes people want to make us jealous and say, I'm going to Hawaii in November. You can still do that. All right. When I call your number, please lower it. Number 5. And everyone, now's the time to let me know. So once I pass over this box, so number 5 is the only person in this box who has time issues. All right. 24. Anyone else on this side? Number 40. Anyone else on this side? All right. This side, we have 57, 60, and 63. All right. Number 5, what is your constraint?
It's starting Sunday through Friday of next week.
All right. And where are you headed? Boston? What are you doing in Boston? All right.
My wife.
Does she want you there? She want to do it by herself? She wants you there? All right. I always have to ask that question. I asked it of the ladies too, when they say, I'm going on vacation with my husband. I'm like, does he want you there? Number 24.
October 1st, my father's having surgery. I need to take care of him. I'll be going to California.
All right. I know everything is going to turn out well. Thank you. Number 40.
Yes, ma'am. My son is going to Fort Benning for a training in the military base on the 25th, and I have to meet him there.
All right. September 25th.
Yes.
All right. Thank you. Number 57.
I'll be going to Del Rio tomorrow.
All right. What are you doing in Del Rio?
Work.
Work. Oh, what do you do?
Phlebotomist.
All right. Great. But what are you going to be doing there?
Closing up a location and moving to a different one.
All right. So are you driving?
Yes,
How long is that drive?
3 hours.
Ah, okay. All right. Thank you. Number 60.
I leave Tuesday to San Jose for a wedding.
I'm sorry, to where?
San Jose, California for a wedding.
All right. Whose wedding?
My niece
Have you already bought her gift?
Haven't bought her gift, just the tickets.
All right, thank you. Number 63.
This weekend is my dad's birthday. We're going to Pagosa Springs, Colorado.
I'm sorry, could you speak up a little?
We're going to Pagosa Springs, Colorado for his birthday.
All right, who's all going?
My immediate family.
Okay. All right, what's the temperature?
Cold.
All right, are you gonna go there and
We're going
bring
camping.
the 100-degree weather from here?
I'm sorry.
Are you gonna go there and bring the 100-degree weather from here there? They won't like you if you do that. All right, and what day are you leaving?
Friday afternoon.
Friday, all right. All right, thank you. All right, so all of you now have had a chance to sort of see each other speak and get to know who the parties are here on the panel. Other than meeting downstairs, other than having a glorious time standing outside, do any of you know each other other than meeting at those specific times? Well, number 12, somebody better raise their card. 12, 19, anyone else? All right, number 12, how do you know number 19?
Kids grew up together, we lived in the same neighborhood.
Okay. We've had some people on the panel who know each other because it's teachers with their students. We had the ex-wife and the new wife. Believe it or not, they got along fine. The people who did not get along fine was, I think it was a sister or somebody, and there was a bad breakup. And I just asked the question, I said, so there's no bad blood between you all, is there? Yes, there is. That was the answer. So this is great. All right, before I turn it over to the state and the defense, I'm going to tell you all 2 stories. Both of them are true. The first story is about jury duty. I know that jury duty is an inconvenience because you have to come downtown. You get the notice in the mail, you're like, why me? And then you come downtown, then maybe it's hot down here. They make you pay for parking, which I believe that you shouldn't have to pay for parking, but I'm not in charge of that. And then when you're driving downtown, if you are not down here on a regular basis, there are a bunch of one-ways, and it doesn't improve the flow of traffic, but whoever planned the city thinks one-ways improves the flow of traffic, when really it just makes you burn more gas because you're driving downtown and you're like, if I could just turn left, the building is right there. So I understand it's an inconvenience. And the reason why I say it's an inconvenience is because your country doesn't ask a lot of you. You have to pay taxes and do jury duty. That's what those are the 2 things they're asking of you. My mother grew up in a small town in Louisiana called Grand Cane, Louisiana, extremely small. And my grandmother had 2 boys, rest were girls. And I'll have to think in my mind to give you the number. But so anyway, her firstborn was a male, my uncle. He would go through school and he was super intelligent. They would pass him. When computers first came out, he knew all about it. So when he graduated from high school, and he graduated before he was really of age because the teachers kept passing him, he graduates. And then the rest of his siblings start coming through school. And as you can imagine, everybody goes to the same school. Everybody knows everybody. It's not like you have classrooms now where maybe there are 80 people in a classroom. The teachers really knew them. They knew every parent. So when his siblings went to class behind him, all the teachers would say, hey, your brother's super intelligent. We're expecting the same from you all. So when he graduates, the Vietnam War breaks out. And he goes to my grandmother and he tells my grandmother, I'm not going to be able to be who I want to be or do what I want to do because there are too many constraints here. So I'm just going to go off and serve into the war. That was a sacrifice. And let me just tell you why it was a sacrifice. 1, my grandmother never heard of Vietnam. And before the Vietnam broke out, honestly, a majority of the people in the United States, what my mom later tells me, Nobody knew where this place was. They're like, what's this about? Where's this place? So my grandmother had to sign a form for her firstborn to go off and fight in the war because and my uncle told her, they're already drafting all the boys here anyway. I'm not going to be able to do anything here, and sign for me. So when you think about it, her signing for him, when they're in a time frame where their phone, in order to get a call out, and some of you may remember this, their phone number was 4 digits. And it wasn't where you dial or push the buttons. It was like you pick up the phone, you call the operator, and the operator's, who may I connect you with? And you give them the 4 numbers, and that's how it was. Didn't have a computer, barely had just got a television. And as you know, when you had those televisions, there was no cable. You had the little rabbit ears, and NBC wouldn't last you could barely get in NBC. If on a good day, you could get NBC. And then that was the time when the stations ended at a specific time where they play the national anthem, then everything goes dark. So imagine her sacrifice where she's sending her firstborn off to Vietnam. There's no email. There's no get on the phone call. Did you make it there safely? All of it is snail mail. Like, where's my son stationed? None of that. So I bring that story up to let you know that jury duty is really an inconvenience. It's not a sacrifice. And it's this small window in your life. And after you do your service, it's going to be a while before your number comes up again. So I always tell people that story so you can put jury service in perspective. And my uncle has since passed, but he did come back from the war. The other story I want to tell you is about my friend I went to law school with. She decided to do civil law. I always wanted to do criminal law because I always loved criminal law. So people who practice criminal law, they're usually in court every single day. They're in trial a lot. I used to be in trial a lot. And so she tells me she's been called up for jury duty. Let's get together. Let's have lunch. I'm like, great, let's do lunch. So we have lunch and I ask her, how's jury duty going? She's like, fabulous. I'm thinking to myself, now that I'm a judge, how can it be fabulous? You're not with me. I'm not doing the jury selection. So she tells me, I'm not getting selected. It's just like in law school. I'm like, what do you mean? She's like, I'm at the back. I'm keeping my head down. I'm not asking any questions. And I laugh. She's like, what's so funny? I'm like, oh, we're going to get to have lunch all week because you're so going to be on the jury. And I tell that story because when jury selection is happening, what ends up happening is usually the people who are very quiet end up on a jury. And the only other way to make sure you're on a jury is to raise your card and say, please choose me. And I tell that story because both the state and the defense, and in this case, the state is going to have 30 minutes to speak to you. The defense is going to have 30 minutes to speak to you. And they are trying to get to know you to make sure that you will be suitable people for this jury. And I realize that everyone has things perhaps that have happened to their background, but the key question on whether or not you can be fair is whether or not, if you're on this jury, would you be able to base whatever decision you come to, if you can come to a decision based upon what you hear inside the courtroom? Does everybody understand? Yes. So is there anyone here who would not be able to base whatever decision you come to on this case, if you can come to a decision based upon what you hear inside the courtroom? Is there anyone who would not be able to do that? Okay. So before I turn it over to the state and the defense, I'm going to ask, does anyone need a break?
Yes.
All right. So this is what we're going to do. I'm going to give you all a break until 2:35. What that means is everyone will need to step out of the courtroom together. You can leave your personal items. We'll still be in here. If you need to use the restroom, find the stairs. And once you find the stairs, you can go on any floor in this courthouse. There's a restroom on either side of the stairwell. Look to your left. Look to your right. That is your jury everybody make sure that they are standing in line. So when you come back, do not come inside the courtroom. Just stand out in line, and it'll make things go quicker if everybody can remember your number and get in line that way outside. Leave your numbers behind. Everyone, please rise for the juror.
I gotta go to the table.
You can walk out.
In case.
Please leave your numbers behind. I'll find you.
I know. I really be cold and hot.
Me too. Shivers to the sweat.
Yeah.
There's that super aggravated that. Is that here in town?
Yeah, it's supposed to be.
You guys belong back there?
Yes.
So you cut to the line?
Oh, we were
Oh,
supposed,
you didn't know?
we didn't know. we were supposed to be-
I'll go fly to work.
Yes, I wanted, they said you can go ahead and vote.
It doesn't matter.
We did ask.
You're just being.
Oh, sorry. I was telling her we were last anyway, so like, you know, go ahead and go.
We go back out.
You're right.
Okay.
He's giving everybody the line.
Right. As far as counting.
Yeah. It's just what you
Sorry.
I was either gonna do it here today or tomorrow.
That seems to be happening a lot.
Then when you go to the theater, excuse me.
Process.
Yeah, that's why.
It's been happening for me since April.
Rough, isn't it?
It sucks.
Yeah, I'm trying to get ready.
I can't take a week. off.
Yeah.
I'm weak. I'm very good one month. Usually 2 days.
My wife's right after me working. Yeah.
All right, everyone, please be seated. All right, State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
Thank you. Good afternoon, ladies and gentlemen. Again, my name is Ruben Herrera. I'm an attorney with the state of Texas. And as the judge has been telling you, since y'all walked in, you all are here for jury selection today. So what is jury selection? It's really the only time that attorneys for the state and defense are going to get to have a conversation with you up until this trial is complete. The purpose of jury selection is to find 12 fair, unbiased people to sit on the jury to hear the facts of the case and eventually determine the guilt or not guilt of the defendant. Like Judge told you, we can't get into the specific facts of the case, so everything that we say and talk about today will be taken in the general context as to bring out different ideas from all of y'all, bring out your opinions, bring out your stance on certain subjects so that we can find those 12 fair and unbiased jurors. Again, you've already been warned, speak up. There's no wrong answers. If you look at your feet, there's no trap doors for answering the question the wrong way. You don't actually have to check, you can trust me on that. The purpose again is we just want to see how you all think so we can find people who will be a good fit for jurors for this type of case. Most importantly, again, the quiet ones are the ones that are going to get picked. So the more often you talk, the better the chance you'll say something that either us for the state or the defense doesn't like, and you will not be sitting on this jury. So I wanted to start off real quick by asking everybody here, who is this person? Billy Nelson, perfect. Sounded like all of y'all answered, so I'm going to pick a person at random. Number 32. If you can stand up, please. What is Willie Nelson's favorite activity? There you go. Now, you can take a seat. Thank you very much. Now, if this were a possession of marijuana case, would Willie Nelson be the best juror to be sitting on a case like that? No. Number 43, if you can stand up, please. Why wouldn't Willie Nelson be a good juror on a possession of marijuana case? There you go. So it's fair to say that he would probably be biased in his views of marijuana, correct? Thank you. So exactly my point. We're trying to find 12 fair and impartial jurors. So a fair and impartial juror, what is that? It's a person who will follow the law that the judge gives you after hearing all the evidence and all the facts in the case, as well as someone who bases their decision based only on the facts that are presented in this case. So that's our goal today. I wanted to start off by going through a couple different things that are going to come up on both sides, and then we can move on a little bit more. But it's the state's burden, as judges told you, to prove our case beyond a reasonable doubt. So what's beyond a reasonable doubt? When you hear that, it doesn't mean all doubt. Doesn't mean we have to prove that the events that are alleged in the case occurred 100% to every single detail. What it does mean is we have to prove it beyond all reasonable doubt. Now, just because something is possible doesn't mean it's reasonable. Reasonable doubt only applies additionally to the elements of the offense. So, for example, if one person's story says that man was wearing a blue shirt, and then another person says he was wearing a red shirt, it's reasonable to doubt that. However, that's not an element of the case that we have to prove. So you can have a reasonable doubt as to that. However, the elements of the case that the state has the burden of proving, and I'll go further into detail on the elements of the case here, are not, you cannot have reasonable doubt as to those facts. Any other facts that are not an element and that are required to be proven by the state, you can have reasonable doubt about that. But we don't have to prove every single detail 100% beyond a reasonable doubt. So when you're asking yourself if we have proven our case beyond a reasonable doubt, number one, ask yourself, do I have a doubt? What, and you can, again, like I said, you can have doubts. But number two, is that doubt reasonable? And number three, does it go towards one of the elements that the state is required? So if y'all are selected and you go to the back of the jury and to the jury deliberation room, those are the questions that you're going to be required to ask yourself. All right. So to illustrate this point, I have this picture here. Now, this isn't my dog, but my dog does the exact same thing. I'm always too mad to take a picture for myself. But juror number 45, if you can stand up, please. From looking at this picture, what do you think happened here?
They had a wild night and decided to eat the furniture.
Who did?
The dog.
The dog. There you go. Now, you can take a seat. Thank you very much. Now, juror number 18. Is it possible that somebody was walking by and looked through your window and said, I hate that chair, broke into your house, cut it up, and then left? Is it possible?
I mean, it could be possible.
Okay, but is that reasonable given what you're seeing here? No? Okay, and that's what I'm trying to illustrate to you. You can have, something could be possible to have occurred, but ask yourself, is it reasonable given the facts that are presented to you? Okay? So the defendant in this case is charged with two different counts. Count one is aggravated assault with a deadly weapon. And these are the elements that the state is required to prove. We have to prove that on or about some date in Bexar County, Texas, the defendant intentionally, knowingly, or recklessly caused bodily injury to the complainant, who was a family member of the defendant, and during the assault used or exhibited a deadly weapon. Again, these are the elements of the crime that the state has the burden of proving beyond a reasonable doubt. We can go a little bit further into those. So first of all, what is an assault? And in the state of Texas, there's two different categories of assault. One is causing injury. So they intentionally, knowingly, or recklessly caused bodily injury to the complainant. And number two is through a threat, in that they intentionally or knowingly threatened imminent bodily injury. Okay. Now, that language, intentionally, knowingly, or recklessly, the state isn't required to prove all of them, but we do have the burden of proving beyond a reasonable doubt that one of those mental states existed at the time. So what is intentionally? It's a conscious objective or desire to engage in the conduct or cause the result. So for an example, if I grab, let's say that my partner Travis's water bottle doesn't have a cap on it. I pick it up and I pour it out. I pour out all the water. I'm intentionally doing that. I want to pour the water out of that water bottle, get the carpet wet, right? Now, knowingly means that the person is aware that the conduct is reasonably certain to cause the result. So if I grab it, unscrew the cap, and tip it over the table, I'm not intentionally pouring the water out, but I do know that by tipping that water bottle over, that water bottle is going to spill water onto the carpet, right? I'm not intentionally pouring it. This time I'm not flipping that water bottle over to get the water out.
I need you to slow down.
Sorry about that. But I do know that by knocking that water bottle over, it's going to cause the water to spill. Okay, everybody following along at this point? And finally, recklessly means that the person is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. So to illustrate this, I'm going to use a different example. If you go to Market Square during Fiesta, there's a ton of people there all the time, right? If I stand up on top of one of the buildings and I throw a baseball over the back of my head, I'm not meaning to hit somebody in the head with that baseball. And I don't know that it's in fact going to hit somebody in the head. But if I throw it out there, knowing that there's people walking around out there, I'm recklessly throwing that because it is an unjustifiable risk that I'm taking by throwing that into a crowd. Okay. So now, as long as the state proves one of these mental states beyond a reasonable doubt, then we've met our burden as to proving that element of the offense. Okay. Now, how do we know that somebody has acted intentionally, knowingly, or recklessly? Anybody have any idea? How can we as the state prove that to you? I'm sorry. Can you stand up for me? And what's your number?
Oh, sorry, 34.
34?
Facts,
Okay, what do you mean by that?
evidence.
Evidence, okay. So by kind of looking at the broad scope of all the facts that are presented, you can kind of determine that. Is that kind of what you're saying? Okay, okay. Anybody have any different ideas?
A witness.
And it's number 19, a witness. How can a witness prove that to you? Through the testimony, right? If they say, yeah, I saw him throw that punch, and he said, I'm gonna punch you and hurt you, that's one way to get it in, right? Okay. Number 65?
Defendant admits it.
Okay, so that's
Sense of guilt.
so in another form of testimony.
Yeah.
Right, okay. So yeah, just kind of like how all of you said, you infer from the facts of the case and the words and actions of the parties. Okay, and that's how we can prove those mental states to you. Because obviously you can't read somebody's mind unless they tell you, or somebody else can tell you that they inferred something, or you infer from the facts that are presented. That's how you can reason. That's how we can prove that to you beyond a reasonable doubt. Now, an element of assault is also causing bodily injury. What is bodily injury? It's physical pain, merely physical pain, illness, or any impairment of physical condition. So that can range from anything from, again, a hard punch leaving bruises to a hair pull and somebody says, ow. Okay. You're not going to see any broken bones or any, torn limbs or anything like that. That would qualify as serious bodily injury, and that would be a different offense than is charged. Okay, so don't expect to see any major injury, but an element of an assault is bodily injury. Okay. And aggravated assault, which the defendant is charged with here, is an assault plus something that makes the assault worse. And those are aggravating factors. So because the defendant's charged with aggravated assault with a deadly weapon, that's the aggravated factor that the state is required to prove. We are required to prove that during the commission of assault, the defendant used a deadly weapon. And like I just said, another aggravating factor could be serious bodily injury. However, that's not what's being alleged in this particular law. Okay. And what is a deadly weapon? So there's multiple forms of deadly weapons, obviously, but one is a firearm, and under the under Texas law, that is a per se deadly weapon. A firearm is automatically a deadly weapon. A deadly weapon can also be anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. So what kinds of things can be deadly weapons? If you have any ideas, throw your number up. Number 3.
Car.
A car can be a deadly weapon. Number 4.
Baseball bat.
A baseball bat. Yep. Number 25. I'm sorry.
A knife.
A knife. 28.
A wrench.
A wrench. Okay. Number 31.
Brick.
A brick. So the kind of point I'm trying to get across is there's many different things that can be used as a deadly weapon if they're used in a manner that can cause death or bodily injury, right? It's a wide variety of different things. The defendant here is also charged with assault, choking, strangulation. And these are the elements. They differ a little bit from the aggravated assault with a deadly weapon. So to prove this charge, the state has to prove that on or about some date in Bexar County, Texas, the defendant intentionally, knowingly, or recklessly caused bodily injury to the complainant, who was a family member of the defendant, by impeding the normal breathing or circulation of the blood of the victim by applying pressure to the throat or neck, or by blocking the person's nose or mouth. So I really want to just highlight there that there's two different ways that we can prove choking strangulation, right? There's by, well, really there's three different ways: by impeding their breathing or blood, by applying pressure to the throat or neck, or by covering their nose or mouth, okay? Now, these are family violence cases, so I do want to take a little bit of time to discuss what exactly family violence is. Family or dating violence encompasses dating relationships, and that can be current or former partners, spouses, current or former, again, so married or divorced, parents of a child, regardless of their marital status, foster parents and children relationships, and relationships between siblings. Any of those, any relationship that fits any of those criteria fits under the umbrella of what we call family dating violence. So because it's an element in the charge, in the offenses that we are alleging, that is also an element that we have to prove to y'all that are going to sit on that jury, that the relationship between the defendant and the complainant fit under one of those relationships. Family violence also includes an act by a member of a family or household against another member of the family or household. Includes dating violence, like I discussed previously. And dating violence includes an act other than a defensive measure to protect oneself that is committed against the victim with whom the actor has or has had a dating relationship. So like I told you before, it can be that they're currently dating or that they've dated at some time in the past as well. As long as they've dated at some point in their lives, it would fit under that relationship of dating violence. Okay. So I have a question for all of y'all. I do want everybody to answer. There are 4 different categories to this answer. Okay, so I will go through each one. If I'll read the statement, and then if you strongly agree, disagree, agree, or strongly agree, go ahead and raise up your answer. I'm going to go through each one by one. Okay. So the statement that I presented to y'all is family violence is a private matter and the state should not get involved. Who strongly disagrees with that? Go ahead and hold them up high and hold them up till I call out your number. That's number 1, 2, 3. As soon as I call your number, you can go ahead and put it down. 4, 5, 6. Number 7, are you putting your number down? Okay. 8, 10, 11, 12, 13, 15, 16, 17, 19, 22, 23, 24, 28, 30, 31, 32, 36, 37, 38, 41, 43, 44, 45, 48, 49, 50, 51, 55, 56, 57, 61, 62, 70, 71, 72, and 75. Okay, y'all can go ahead and put your number down. Who here disagrees with that statement? 9, 14, 18, 21, 25, 26, 27, 29, 33, 34, 39, 40, 42, 46, 47, 53, 54, 58, 59, 60, 63, 64, 65, 66, 73, and 74. And 65.
Can I change mine to strongly disagree?
So 65, you're strongly disagree?
Yeah.
Okay.
I'm sorry, number 1, I'd like to change mine as well.
Just strongly disagree as well? Okay, so number 1 is also strongly disagree. Who agrees with that statement? That family violence is a private matter, state shouldn't get involved. Number 7, number 20, and number 69. And is there anybody here that strongly agrees with that statement? Okay, I'll move on. So why is it important to prosecute family violence cases? Number 28, if you can stand up for me.
I believe that it is important to prosecute family violence cases because any sort of assault, if anybody commits any sort of like attack on someone, they should be prosecuted and convicted of that misdemeanor.
Okay. Who here agrees with number 28? That it's because it's a crime, it should be prosecuted. Anybody else feel the same way? Okay, number, go ahead and hold up your numbers. I'm gonna go ahead and call them out. 4, 5, 10, 11, 12, 13, 15, 16, 17, 19, 21, 22 through 25, 29, 30 through 36, 37, 38, 40, 41, 42, 45, 48, 49, 51, 53 and 54, 57, 61 through 66, 69 through 72, 74 and 75. Is there anybody that has a different reason or that feels that it's important for a different reason? Number 56?
Well, it's a little bit the same, but for me, I think they should get involved because who would protect the most vulnerable if we were not there? Like if the state wasn't there.
Okay, so you've kind of, the state should get involved because there's nobody else that will.
Yeah, it should be prosecuted if it's determined that it's or how would you say like if it's to the extent of being prosecuted, but it should always be what's the word? I'm looking for a word. It should always be investigated.
Okay.
Yeah.
Okay,
To
thank you.
protect for protection of the most vulnerable.
Number 65?
Well, if it's a family crime, those persons are living with them or they have relations with them versus it being another bystander. And it's more than likely to get covered up. And it's more personal because there's some type of relation that's there. So it should be prosecuted even more so.
Okay.
Excuse me. That gentleman is raising his hand.
Oh, I'm sorry, 59.
I've got a question.
Yes.
Are we talking about the district attorney getting involved with that particular prosecution or somebody calling it in and having the police do their investigation before it goes on? Because I see the two as being different.
Of course, and so right now I'm just talking strictly about prosecution. But I do want to know, my next question is, why would it be sometimes that a victim of family violence wouldn't speak up? Number 38.
Sometimes in situations they have no way to escape it. They could have been in that relationship where they always felt loved and everything. They see it as a way of being loved. They don't understand it as a way of this is an act against the patient. It's kind of a mental brainwash scenario. And also they may not have a way to escape the situation where they can go anywhere. They could be in different situations.
I'm sorry.
Can you speak up a little bit more so the court reporter can hear you?
Prosecution will, prosecution and moving them into this situation will allow that person to figure out how to move on.
Okay. Number 25.
Much the same thing, just they can feel scared.
Okay, so they feel scared. Okay. Number 50.
It could be a fear of loss of resources, so they wouldn't want to report it because they could lose their house, the money, or their family.
Find support maybe by the actors.
Yes.
Number 61.
It could be shame or embarrassment of what's happening.
Can you say that one more time?
Shame or embarrassment.
Okay. And number 15.
Actually love the person, violator, and want what's best.
Who are typically who are the victims of family violence? Number 18.
Children.
Children could be if they're involved in the relationship. Anybody have anything different? 28.
A spouse.
The spouse. Okay. Anybody else? 51.
It's typically
Women? Okay, what makes you say that?
It's, well, assuming the statistics are right. Women are more often victims of violent crime in family relationships.
Okay.
Women and children.
And you can go ahead and sit down, this is an open question, what about, obviously, number 51 brought up statistics. What about women makes them more vulnerable than men in a family violence relationship? Number 17, okay. Anybody else? 16,
They might be dependent money wise or financially.
okay, okay. I'll move on a little bit. Do victims of family violence always leave their abusers?
No.
Why not?
Can't fear.
They're afraid to leave the relationship? Okay, number 12? Okay, financial issues. Number 46?
They might be threatened if they leave.
Okay. Let's see, number 71.
The victim, whether male or female, not want to keep it quiet because they want to keep the children safe.
Okay, so keeping the family together. Anybody else? Number 15? Number 3?
Because they've been mentally abused for years and they're afraid to speak out.
Okay, yeah, these are all reasons, and you can go ahead and put your numbers on, I'm gonna move on a little bit. But they're all reasons, common reasons that victims may not speak up. And that's why kind of family violence may sometimes more often than other crimes get pushed under the rug. Now, who can be a victim of or a complainant of family violence? Number 28.
Really, any family member can be a victim.
Okay, yeah, so I had a couple of examples. That was the answer I was looking for, actually. Can a homeless person be a victim of family violence?
Yes.
Yeah.
Yes. What about a drug addict, someone who's addicted to drugs? Can they still be a victim of family violence?
Yes.
Can a college student be a victim of family violence?
Yes.
What about a pro athlete? Can they be a victim?
Yes.
5
Yeah.
minutes.
So yeah, just like number 28 said, anyone can be a victim. And that's kind of the idea that you should be taking in as we present the facts of the case to you. So now witnesses in family violence cases, where do these family violence cases typically occur? The home, okay, so who's usually around at those times when an action of family violence occurs? Children can be, family, okay, does this usually happen behind closed doors though?
Yeah.
So more oftentimes, it's really just the defendant and the complainant, is that true? Okay, so how many actual witnesses are usually able to testify in cases like these? And also remembering, like the judge admonished you, the defendant doesn't have to testify. How many people does that really leave that knows the story of what happened? One. Now, is that a problem for anyone if they only hear from the complainant and nobody else? Would they not be able to find the defendant guilty based on the testimony of one person? You can go ahead and raise your hand if that is you. And like I said, there's no wrong answer. 1, 3, 4, 11, 12, 13, 18 through 21, 25, 26, 28, 29, 33, 38, 40, 57, 63, 66, 69, and 75.
Counsel, if I could just pause, I'm gonna pause your
Yes,
time for a moment. So ladies and gentlemen, I'm gonna give you a hypothetical. The hypothetical that I'm gonna give you, do not add to the hypothetical at all. So if someone were robbed in a dark alley, and there are only 2 people there, it's the person who was robbed and the person who robbed them. Does everybody understand the hypothetical?
Yes.
How many people here think that that case should be prosecuted? Raise your card if you think that case should be prosecuted. All right, lower your card. So let's say in the hypothetical I'm going to give you, someone comes to testify. They raise their hand, I give them the oath. And the oath is for them to swear to tell the truth. So help you God. And they raised their hand and they said, yes, I will tell the truth. And the person who's coming to testify is from that hypothetical that I just gave you. There's no problem with that person's vision. They do not wear glasses. They have 20/20 vision. And they come in and they say, I was robbed. This is the day I was robbed on. This is the person who robbed me. I see them. This was the description of the person. And this is the person sitting right there in that chair who robbed me. And you listen to their testimony and you believe it. You don't have any question about whether they're telling the truth. You find them credible. And that one witness proves the state's case. Does everybody understand the hypothetical? The person who's testifying could be Mother Teresa, whoever it is, but it's someone that you find credible after listening to their testimony. Is there anyone here in that fact scenario, you believe that witness? That witness proves the state's case beyond a reasonable doubt. It proves every element. It proves the day it happened. It proves that it happened in Bexar County, and it proves all the elements of robbery. And you believe them. Is there anyone here who, one, thinks that that case should never have been brought for you to hear? Raise your card if you think that case should not have been brought. All right, I see no cards. Number two, is there anyone here in that fact scenario where you believe that witness and that witness proves the state's case would not be able to find someone guilty? That's sort of the fact scenario that the state has just given you. Does everyone understand?
Yes, sir.
All right, state, you can re-ask your question.
Thank you, Your Honor. So is there, again, taking judge's hypothetical in the question, is there anybody who would not be able to find the defendant guilty based on the testimony of just one witness? Number 63. Go ahead, number 20.
Number 1.
Oh, number 2. Oh, sorry, I thought you had a question. And number
No,
1?
no.
Okay. All right. Move on to this. Move on. Yeah. So the evidence that the state's going to provide, again, I already told y'all, testimony is evidence. So testimony, if it's one witness or multiple witnesses, all of the testimony that's provided is evidence that you'll be able to take into account and deliberate over when deliberating over your verdict. What types of and kind of evidence would you expect to see in cases like this? There'd be, would anybody expect to see photos, videos, other witnesses? Those are kind of the types of evidence you expect to see in all kinds of cases, right? However, in family violence cases, like we went over, because it happens behind closed doors, there's not always that evidence. If it happens at home, not everybody has a multi-million-dollar security system that's going to capture every movement. They're not going to be able to whip out a phone and take out pictures because it kind of happens pretty quickly. And like we said, there might not always be other witnesses. So sometimes all we have is a testimony of witnesses who were there to be able to give you their account of what happened. And that's really a common form of evidence that state presents in these kind of cases. Is there anybody who needs any of this type of evidence in order to reach a verdict, that they would require more than just testimony? Number 1, 2, 3, 11, 12, 13, 18, 20, 21, 26 through 29, 31, 32, 40, 53, 54, 55, 63, 69, and 72. And judge kind of went over this already through punishment, so I'll breeze through this. Number 7. Yes.
You say that, you mean testimony of that event or past events?
Well, we're required to prove this event, so it would be testimony of this event, and without photographs, evidence, or any other type of photographs, videos, or any other type of evidence, would you require more than just testimony evidence to be able to reach a verdict? Okay. Again, Judge went over this already, so there's two phases in the criminal trial, guilt, innocence, and punishment. And the defendant is charged with aggravated assault with a deadly weapon. That's a second-degree felony. It's 2 to 20 years in prison. Assault, choking, strangulation is the second charge. Third-degree felony punishment is 2 to 10 years in prison.
All right, state time.
Thank you, Your Honor. And I will pass it off to defense. Thank you very much, everybody.
And so, ladies and gentlemen, before it's passed off to the defense, what I want you to realize is that testimony is evidence. So what people say, that's why in my hypothetical, I was asking you and giving you the hypothetical where you find the witness credible. So when people are sworn in to testify, what they say is evidence. Sometimes people think of evidence as, oh, we're bringing a video, we're bringing a photograph. And that's all they think of as evidence. But what people say when they're on the witness stand and under oath is evidence. That's why you're in charge of judging whether somebody's credible or not credible. Does everyone understand? All right. Defense.
Want me to go? Yes. Can you swap us across, please?
Yes.
Howdy, folks. Yes, I am an Aggie.
Yay.
My name is Robert Featherston. And myself and William Davidson are taking care of Melvin Owens. Melvin, could you stand up, please? So Melvin's been accused of 2 crimes. He's accused. Melvin, you go ahead and sit down now. Now, state did a very good job, and you guys participated. That was great. Who ate downstairs today? Did I eat downstairs? Well, my apologies to you. I didn't think you would be participating as well as you did for eating downstairs. That's pretty good. Who went to Chick-fil-A? Ah, I'm jealous. You walk to Chick-fil-A, I'm jealous. Okay. Participation. You did a very good job with the state. And that's really all we're asking of you is to participate and be honest with your answer. No one is here to change your mind, but we want to know what your mind is with respect to a particular question that we're asking. Okay. State's been talking about aggravated assault, deadly weapon, and assault family choking cases. And all of you have got a picture in your mind associated with those particular allegations, right? Yes. Who would say no to that? Everybody has an imagination, right? Yes. Okay, and so what we've talked about so far, you're coming up with your own particular scenario that might fit what the state's been talking about. Does anybody disagree with that?
No.
It's okay if you do. Again, all I just want to know is how is your viewpoint on it, how you feel about it. Well, I made this slide up today because I saw an article in the paper. And I want to show you that article. It was entitled Kansas Killer. And so for those of you in the way back of the room, I'll read it to you. Transported to a surreal location, a young girl kills the first woman she meets, then teams up with 3 complete strangers to kill again. And it is Kansas, you know. Is everybody here from Kansas? All good Texans?
No.
So what state are you from? sir?
Or in New York.
New York,
Stand,
okay.
stand,
I'm
please,
gonna
so the,
remember that.
make sure you
All right.
stand so the court reporter can hear.
That's okay. That's okay. All right, so. What type of imagination do you have from a statement like this that you read in the newspaper? Am I looking at another serial killer? What am I looking at here? Are you interested enough to maybe read the rest of the article? What do you think? Who here thinks that that's a really bad young lady? Raise your hand if you think it's a bad young lady. Okay, pretty natural. But we're really talking about the Wizard of Oz. But you know, why is a stupid defense attorney in here talking about the Wizard of Oz? Why am I talking about Dorothy? I'm talking to you about Dorothy because of confirmation bias. Confirmation bias. This young man, and I'm sure he's younger than I am, okay, he's been accused of an aggravated assault with a deadly weapon and assault family choking. Confirmation bias. If you're on this jury panel, you're going to swear an oath to wait until you've heard all of the evidence before you make up your mind. You're going to swear an oath to do that because that's the law. And all that we care about is that you follow the law. Now, who's looking at me and saying, you know, Featherston, you're just absolutely crazy. Okay, I've already made up my mind. Or I'm going to make up my mind as I'm hearing the testimony. Is there anybody here that feels that way? It's okay if you do. All right. Okay, the law does presume the defendant to be what? I'm sorry, I couldn't hear that.
Innocent until proven guilty.
Innocent till proven guilty. Okay, that's very good. Because that's exact. And it doesn't matter that he was arrested. It doesn't matter that he was indicted. All an indictment is a way for the state to proceed forward with their case. And who has to prove their case? The state has to prove their case. Okay. Is there anybody in here that can't say that as Mr. Owens is sitting here right now, he's not innocent? I mean, for some folks, that's quite a stretch. Saying, well, you know, he's sitting here, he's been through indictment, well, he's got to be guilty somehow. But that's not our law. Again, all I'm interested in is getting 12 folks that can follow the law. And the law is he's presumed innocent. Who can't do that? If you can, it's okay. But who can't do that? Yes, ma'am. And what's your number?
54.
54. You know, God bless you for being honest. Because that's all we want here. Anybody else?
Clarify.
Okay, clarify. What do you need?
To clarify, these charges, they're against a family member, correct?
You'll find out that when the indictment is read. What you know right now is that there's an aggravated assault, deadly weapon allegation, and an assault family choking allegation. And of course, you know, when I say assault family choking allegation, well, there is the word family in there. Okay, did that answer your question?
Yes.
Okay, very good. Okay, we've already gone through that. Okay, I'm gonna put all these up here at once. if you meet me or you meet Bill in the hall, okay, we're gonna kind of ignore you. And the same is true for the state. We're really not supposed to talk with you. So please don't take offense. If you see us walking down the hall and we don't say anything to you. Cause that could cause all sorts of problems if we get in a conversation with you. Okay, but it's not because we're trying to ignore you. Anybody got a physical problem that they just can't sit for a few days and listen to testimony? Anybody? Number one?
I got sciatic nerve pain in the back, so
Okay,
video might show me twisting around.
okay, we may ask you some more about that in a bit. All right. Anybody heard publicity about this case?
No.
Okay, all right. Is there anybody, you just can't serve as a juror, you just can't do it. It's just not in you. Anybody? Number 54. Hey, thank you, ma'am, appreciate it.
Another one.
Another one. 57, okay? And please note that. Thank you. Okay, and number 28. Anybody else? Number 3. All right. Anybody else? I guess that's 44. There you go. Thank you so much. Anybody else? Okay, victims of a crime. Anybody a victim of assault? All righty, let me read these off. 11, 12, 7, 17, 25, 35, 40, 37, 38, 48, 49, 54, 57, and 61. Okay,
I have a question.
yes, ma'am.
Victim of a crime, is this just for, okay, and that would be certain kind of that did not get.
Yes, ma'am. And tell you what, we'll ask you about that a little later, okay, for number 10. Bill, please note number 10. Okay, and I had specifically asked about assault cases, but is there another type of crime that someone was a victim of?
I have a question.
Right, 65 now, please, and yes, ma'am, number 3.
I have a question pertaining to an experience, a life experience of the same nature of this particular case
Yes, ma'am.
that directly affected myself and my husband.
Okay,
That's almost the exact same crime that my husband was falsely accused of for 2 years.
okay.
That, how does that fall into feeling like if you can be a juror on a particular case?
Well, that's a very good question. And it really boils down to, can you follow the law? And here the law says there's a presumption of innocence, that you have to listen to all of the evidence prior to getting together with the other 11 folks and making a decision about the case. And really, I guess it boils down to you have to take into account your personal experiences. And based upon your personal experiences, are you leaning to one side or the other, to the defendant or to the state? Just right off the bat, with no testimony given, you're leaning one way or the other, because that's really a bias. And if you have a bias like that, then really maybe this is not the trial you need to be on. It doesn't mean you're a bad person. It doesn't mean that we don't like you. It just means that that's you. And that's okay to be you. And we need to know if you're biased. So is there anybody here that's leaning one way or the other with respect to this case? If you are, raise your card. Okay, I'll start here. 1, 2, 3, 11, 12, 13, 17, 22, 25, 31, 40, 65, and 54, I'm sure that you wanted to raise your card too, didn't you? Okay, great. Is there anybody here that is a member of law enforcement? How about relatives? Okay.
I'm the peace officer, I'm just not, I don't have a commission with somebody yet.
Okay, all right. Where are you looking to get off?
Constable's office.
Well, good, good. Okay, so let me get your numbers down. Okay, 1, 11, 18, 28, 29, 41, 60, 66, and 65. Okay, thank you.
Excuse me, I have a question.
there we go.
Excuse me, someone has a question for you.
Yes, yes, ma'am.
When you say,
Please stand up.
I'm sorry, when you say family member of law enforcement, is like I have a cousin, but in another state far away? Is that?
Is it Arkansas?
Doing that.
Okay, I think Elvis said it was a kissing cousin.
Oh.
No, cousins are fine.
Okay.
Does brother-in-law?
Yes, ma'am.
Not me, that I don't have a relative, but my husband's cousin is law enforcement.
Okay,
Does that count against anything or?
well, it really depends upon if you have a bias.
No.
Okay, a bias either for the state or a bias for the defense as a result of that relationship. And that's really the question that we're asking here. Number 28. Do you have a bias because of law enforcement?
I don't believe I do.
Okay, fair enough. Anybody else? Okay, smartphones, social media. The judge is going to give you all an instruction that you are forbidden to look up anything to do with this case on the internet, social media, phone calls, Snapchat, Instagram, the whole list, okay? You can't look for stuff on this trial, including YouTube. Okay. The desire may be irresistible to you. And if it's irresistible to you, it's best you tell us now that, man, I'm addicted to YouTube and I'm going to watch whatever I want to watch. It's okay for you to tell us that, but we need to know that. Anybody find themselves in that position? Number 72. Okay, again, bless your heart for being honest with us. Number 72. Anybody else? Number 70. Could you stand up, sir? Man, I would never have known you were addicted to YouTube. Is that okay? Is that a fair assumption that you would look on some type of social media?
Yeah, I'm usually a pretty inquisitive person.
Okay. All right, let me just pause you for a moment, counsel.
Yes, ma'am.
So everyone, everything about this trial, if you are placed on this jury, is to come from inside the courtroom. Nobody is to go anywhere and do any research because you are not the detective. You are not the witness. Does everyone understand?
Yes, ma'am.
And that means that if something were on the news, you're not allowed to watch it. That means if there is somebody who uses a term that you don't understand, and neither the state or the defense had that person explain that term, you're not to go to Webster's dictionary or go online and look at it. Does everyone understand?
Yes,
Is there anyone here, if you are given instruction that everything that you need to know about this case is to come from inside this courtroom and nowhere else, is there anyone here who will not follow the court's instruction? If not, raise your hand. All right, anyone who won't be able to follow that instruction? Number 72, will you be able to follow that instruction?
70.
I'm sorry, 70, will you be able to follow that instruction? If the answer is no, tell us now.
If be difficult to.
No, it's either yes or no. For example, when attorneys are asking you questions and they need a yes or no answer. Let me give you an example. This case is extremely important. If your significant other comes to you and says, I want to go to Vegas with my friends, and you say, honey, that's fine. You can go to Vegas happy. They have a big smile on their face. They have their carry-on luggage. They're leaving. They say, I'll be back on Sunday. And as they're walking out the door, you stop them and you say, oh, by the way, are you going to cheat on me? And their answer to you is, I don't know, maybe, I really can't answer that. Would you accept that as an answer? And I believe the answer is you will not accept that as an answer. So it says that's extremely important to you. This is extremely important, and there are consequences to this. So again, number 70, are you going to disobey the court's orders? And if the answer is yes, that's fine. You will not be arrested. But defense attorney needs to know.
Yes,
Yes, you will disobey the order?
yes.
All right, thank you. You can proceed.
Judge, I really didn't want to talk about that particular scenario in Las Vegas. Okay, these are some of the justifications for some type of criminal responsibility. In other words, you're not going to be held liable if this justification applies. Who decides whether that justification applies? You do. Okay, you do. Self-defense, defense of a third person, protection of life and health, or necessity. If those come up during the course of the trial, the judge is going to give you a jury instruction on what that really means. And all we're asking is that you follow the law. That's all we're asking. Now, if the issue of self-defense is raised, we're not required to prove self-defense. We can raise it, but the state has to prove beyond a reasonable doubt that it does not apply. They have to eliminate all reasonable doubt that it does not apply. Anybody know what apparent danger is? Perceived danger, very good. I'm a police officer. I'm on the street. I come up to a car, and the car leaps towards me, and I fire my weapon at the driver. Do you think that's legal? Maybe yes, maybe no. But apparent danger could be a defense to that scenario. In some scenarios, it's legal to strike first. And all we want you to do is follow the law. If this applies, we want you to be able to follow the law. Okay, I'm running out of time, so I'm going to have to speed up a little bit. It doesn't matter what the object is. A baseball bat, a knife, the state covered it pretty well. It could even be, no, I guess I didn't put it on. It could be a pair of glasses. Okay. Any object could end up being a deadly weapon, depending upon the manner of its use. But for knives, we look at the size, we look at the manner of its use, and we look to see if it's capable of causing death or serious bodily injury. There's a different analysis for someone that's standing right in front of you with a 6-inch, 9-inch kitchen knife, or somebody that's on the other side of the stadium with a pocket knife. Do you see the difference between those two scenarios? Okay, but you have to decide where it fits within the jury instruction for what is a deadly weapon. Okay, burdens of proof. These are the different burdens of proof in the United States judicial system. The first one is reasonable suspicion to investigate. Now, the judge asked how many folks have been pulled over by the police. They have to have at least reasonable suspicion to legally pull you over. Now, if you got a broken tail light, or you failed to signal lane change, or you're speeding, then they may have probable cause to arrest you. Probable cause is a very low standard, but that's the standard for arresting an individual. It's also the standard for an indictment. Probable cause to believe that a crime has been committed. But there are other standards out there. One is called preponderance of the evidence. Preponderance of the evidence. More probable than not, a crime has been committed. That's a civil standard. And usually it involves the exchange of money. Okay. For instance, you're at a bar, you're having a good time, you got a beer mug in your hand, you're not paying attention to what you're doing and being reckless, you throw your beer mug into somebody's face and break their teeth, and they sue you to get their teeth fixed. Preponderance of the evidence is a standard that's used in a civil suit. Then we have clear and convincing evidence. How many folks in here have children? Right. Number 6. How much evidence would it take for the state to take your children away from you? A lot of evidence. Okay, well, that's clear and convincing evidence. That's really what that means. Because that's the family law standard for taking your kids away from you until they're at least 18 years of age. Okay, but beyond the reasonable doubt is a higher burden still. And let me ask you, well, what does that really mean? And let me give you a scenario and let's see if we can figure it out. These burdens of proof are nothing more than a characterization of evidence. A characterization of evidence. How much can I believe this evidence? So the evidence before you is that the sun will rise tomorrow. The sun will rise tomorrow. Who in here can instantly rely on that? Okay. Now, is there some kind of scenario where the sun won't rise tomorrow? What do you think? Get hit by a comet? The sun could blow up? The moon could hit the earth and stop the rotation? And how much of that is reasonable? None of it's reasonable, okay? The sun will rise tomorrow. You can count on that instantly in the most important of your affairs, right? Who agrees with that? Raise your hand if you agree with it. Okay, very good. Okay, so the evidence before you is if I let go of this pen, it's going to hit the floor. Who can instantly rely on that? In the most important of your affairs, you think? Okay, very good. Very good. Now, attorney pen. Red, black, blue, green. Who here can instantly rely upon this as having a red, black, and blue and green pen? Okay, I got a couple. Remember, this is an attorney pen. It's been running around in my pocket. Okay, is that something you can instantly rely upon? The most important of your affairs, that there are 4 pins in here? There are 4 pins in here? Okay, how many people are saying no? Stand up if you're saying. Stand up. Okay, very good. Sit back down again. Well, let me ask you this. Is it more probable than not that there are 4 pins in here?
Yes.
Yes, it's a lower burden, more probable than not that there are 4 pins in here. There's only 3. Just so you know. Okay. But that's a nasty ass defense attorney trick, okay? But it does illustrate the difference between beyond a reasonable doubt and a preponderance of the evidence. Okay, and the standard we use here is what? Beyond a reasonable doubt. Very good. Okay. So this is another way to illustrate it. If you're looking at all of the elements of the case against Mr. Owens, and you're sitting there wringing your hands and saying, gosh, you know, I just don't know if the state's met all their elements. Is that beyond a reasonable doubt?
No.
Okay. Well, say I've got a strong belief. Strong belief. Is that beyond a reasonable doubt?
No.
No, it's not. It's not. You must have no reasonable doubt. No reasonable doubt. Okay, so what do you see here? Where's number 43? Okay, what do you see there? Jumping to conclusions?
Maybe. I don't, you know.
Well,
what,
let me
I
ask you
see-
this.
No.
Is it more probable than not? It's jumping to conclusions? Okay, more probable. How about beyond a reasonable doubt?
No.
Not beyond a reasonable doubt.
No.
How many people here think that that's jumping to conclusions by preponderance of the evidence? Okay, just hold the card up if you do. Okay, that's good. It's okay. Okay, this is your own personal observation. How many think it's beyond a reasonable doubt? I can instantly rely upon it in the most important of my affairs. Anybody here that would say that that's the case? No, you're looking at the crafty old defense attorney and saying, no, that couldn't possibly be the case. Okay, well, you're right, it's not. But why do I put it up there? I put it up there because you've gotten a partial amount of evidence. A partial amount of evidence and confirmation bias is kicked in. Confirmation bias is kicked in. And you need to be aware of that. Confirmation bias is the worst thing that could happen in criminal trial. You've got to keep an open mind and you've got to wait till all the evidence is in before you decide the case. Now, if Melvin decides not to testify, who's going to hold that against him?
No.
Nobody's going to hold that against him? It's okay to say yes if that's the way you feel about it. All right, very good. I like that. Now, is there anybody, I mean, we've gone through two different types of voir dire now. Is there anybody here that's leaning us a little bit towards guilt? And it's going to take something from the defense team to bring that back at this point. Okay, 17, 25, 26, 28, 65, 54, 11, 3, anybody else? It's okay, just how you feel about it. Again, the question is, as Mr. Owens sits here right now, it's going to take some amount of evidence from Mr. Owens in order to bring him back to presumption of innocence. All right.
All right, counsel, you have 5 seconds.
Well, thank you, Judge.
All right, thank you. All right, ladies and gentlemen, I'm going to have you all step outside and I'm going to say we're going to bring you back approximately maybe 4:20. And at that time, you'll know if you're going to be on this jury or not. So the people who are in the box, make sure you take your personal items with you. And everyone, please leave the expensive numbers behind. Number 30. Just 1 second, everyone. It was 4:20. Yes, number 30. Okay. All right. Thank you. All right.
Yes.
Even number, so I'll call you. I'll look for you.
That's travel plans. I'm gonna do.
It is a different family. Right? There's a special number there.
Well, I hope you took good notes, because I didn't take none. while I was saying that.
That's excellent.
Doesn't matter, just have a seat. Not everybody's gonna have a chair. Just go over to wherever it is, just, I'll put in. I'll look to the end. I'll look to the end. Yeah, it's only because it's easier when people walk in. Those are your excuses. I'll look to the end. I'll wait.
Oh,
I'll wait to the end.
you have it all right away. You have it.
It's okay. You're-
I don't know. That's the judge, but I don't know. Why did that vote?
I know.
That's message, maybe it's straight on.
No, just numbers. Have a seat. Not everybody's gonna have a seat. No, it doesn't matter right now. Because not everybody's gonna have a seat. There's a chair right there. Just the bench.
You don't stick with our number?
No, there's no numbers. You're gone. Okay, you're gone.
It's in a Sept.
Not everybody, not everybody's gonna have a seat.
Okay.
Everyone, please, we see it.
All right, ladies and gentlemen, I want to thank you for your service. Of course, we cannot have jury trials unless we have jurors. So I appreciate your coming down. Sorry you had to pay for parking. What you have, I have no control over that. What you have in your hand are the white sheets of paper. Those are your excuses. That's to show that you actually had jury service. Now you will be receiving a check in the mail for your service. You can do one or two things. One, you can donate that to a charity of your choice. They have several charities that are listed in the basement. Or what you can do is you will receive the check in the mail, probably in about 2 months. You will be shocked. You will say, is this real? Then you'll remember the great time that you had in this court with myself and with the prosecutors and defense attorneys. And you will say, oh, yes, this is real. I'm a firm believer that downtown truly is a beautiful area. And sometimes when you live in a city, you just take beauty for granted. Whenever I travel, I always say, do these people know this is the Louvre right here, or this is the Eiffel Tower, or this is the Pantheon? And then I think, I wonder if these people are the same way that people are in San Antonio who say, it's just the Riverwalk. But when you look at it, it's very beautiful. I remember watching a special on PBS. There is someone who paints. And when you're walking along the Riverwalk, if you look to your side where you see the brick that's holding back everything, there are little vignettes that have been painted. And somebody has gone along and painted on there. You can see people having breakfast that they've painted, people having lunch, people playing ball, and it's all there if you just look for it. So there are many beautiful things downtown, and you can take the money that you receive, come downtown for lunch one time and just sit on the Riverwalk. It's not as hot. It's pleasant. You can watch the ducks, and also there are some snakes in the water as well, but you can watch that too. So you're always welcome. We're open court. So you're always welcome to come down anytime. All right. So with that being said, I am going to call the persons who will be on the jury panel. You can go downstairs in the basement and they will validate your parking. All right, thank you all so much. I'll have the deputies get it. Thank you so much. All right, everyone, please be seated because I'm going to try to get you all out of here. So they're going to head into rush hour traffic, but you guys will not because you'll be leaving probably about 5:15 once the deputy gives you your instructions. So we are going to start tomorrow at 1:30. The reason why we're starting at 1:30 is because I have a docket in the morning. So if you want to be assured of getting a parking space, because on Thursday, you have jurors who are still coming in. You have your hand raised? Yes. All right, did you raise?
I know I didn't because I didn't know when it was starting.
All right, let me give instructions and then we'll take that up. And what's your name? All right, just give us a moment, okay? So everyone, we're going to start at 1:30. To be assured of parking space, if you show up here by about 12:15 or 12:30, usually people go off campus. So usually people will leave and go get something else to eat. We do have a refrigerator and microwave. Do we still have the toaster back there? And a toaster back there? Your toaster oven, yes. You're more than welcome to use that. You're more than welcome to bring your lunch. When we start in the morning time, you're more than welcome to bring your breakfast. I will know when this trial or have an idea of when this trial will conclude once I start hearing things. Believe it or not, I hear the evidence sometimes just as you're hearing it. What you know about the case so far is what I know about the case. So once I'm able to hear some of the testimony, I'll be able to give you an idea of when I expect the trial to conclude. I realize the chairs are not that comfortable. I've been working on getting better chairs. There are pillows in the back. You're more than welcome to bring those pillows out with you. If you want to bring a pillow from home, you're more than welcome to bring a pillow from home. If for some reason, when you're coming up here with your pillow, there's an issue with security and they say, we can't let you bring a pillow in, just call us and Deputy Laura will give you the number to call us and we'll make sure you're able to get your pillow in. Sometimes this courtroom is very hot. Sometimes people complain saying it's too cool. I'm of the mind it's better to have it and not need it than to need it and not have it. So we do not have any extra blankets or jackets if it gets too cool in here. And because our temperature in here is usually 90 degrees, when it gets too cold, nobody complains about the cold. You are allowed to bring drinks if you wish to bring drinks with you, but just make sure there's a cap on it because we're trying not to spill anything. Whenever you need a break, just let us know. If you do the break sign, either the state or the defense or the deputies or somebody over here will know it. Sometimes, believe it or not, Diana would know it even though her back is to you. So just let us know whenever you need a break. I do not expect any publicity in this case, but sometimes that happens because sometimes maybe there's only one trial going and people want to come in and view a trial. This case, everything you need to know about this case is to come from inside this courtroom. You're not allowed to look at anything. If you see anything about this case anywhere, turn it off. Do not do any investigation. You don't have to investigate. Guess what? Because everything you need to know about this case is to come from inside this courtroom. If after hearing everything in this case, you're saying, well, I got a question about this. Let me go look into that. Do not look into that because everything that you need to know about this case is to come from inside this courtroom and nowhere else. Does everyone understand?
Yes.
When you're walking around, make sure you have the badges visible. And the reason why is because sometimes prosecutors, defense attorneys will be talking about cases. They may end up talking about this case because sometimes people say, hey, what do you think about this? What do you think about that? And you're not allowed to hear that. So if you have your badge displayed, if somebody's talking about this case or any other case, they'll tell everybody, be quiet, jurors are here. So make sure that those are displayed. Does everyone understand? All right, so we're going to start tomorrow at 1:30. We cannot start tomorrow at 1:30 unless everybody is here at 1:30. Does everyone understand?
Yes.
All right, any other questions? Yes. All right, and which is your name? All right, so Mr. Baltazar and Tanja Dullen. All right, if you'll go back with the deputy, and then we may bring you out for more questioning. All right, everyone, please rise.